Hello, everyone, and welcome to Uncivil Law. I hope you're having a great day. And for today's story, we're talking about Rachel Maddow, who recently had a SLAPP suit dismissed under Anti-SLAPP. She said some things about a different news network, and the other news network sued, and it's been held as to be not defamation. The court has dismissed it. I have some serious reservations about this decision. We're going to read the court's decision and try to analyze it along the way and express some points where I think I disagree with the court's analysis. So let's get started with this. I am right-handed. I am not left-handed. Why? The plaintiff, Herring Networks, owns and operates One American News. On July 22nd, 2019, reporter Kevin Poulsen at the Daily Beast published a story called Trump's New Favorite Channel Employs a Kremlin-Paid Journalist. Poulsen reported that Christiane Ruse, one of the reporters, was on the payroll of Kremlin's official propaganda outlet Sputnik. In short, Poulsen reported that Ruse had been reporting on U.S. politics for OAN since August 2017, and for a lot of time he's been simultaneously writing for Sputnik, a Kremlin-owned newswire that played a role in the Russian 2016 election interference, according to assessment by a U.S. intelligence community. Poulsen opined that Kremlin's propaganda sometimes sneaks into Ruse's segment on unrelated matters and provides examples. Poulsen also quoted former FBI agent Clint Watts, who stated that this completes the merger between Russian state propaganda and American conservative media. We used to think of it as they just have the same views or use the same story leads, but now they have the same personnel. Okay. Later that day, Rachel Maddow discussed the Daily Beast article on her talk show, The Rachel Maddow Show, which airs on MSNBC. The segment was titled, Schaefer, on Trump's favorite network, is on propaganda Kremlin payroll. Maddow opened the segment by informing viewers about the network, calling it a boutique little news outlet that's designed specifically for Trump's mega fans. She pointed out that President Trump previously praised OAN's ratings on Twitter and gave OAN a press pass to the White House. I think John Oliver also did a segment on OAN, yes. Maddow then stated that she had the most perfectly formed story of the day and presented the Daily Beast article. She stated that the article reports that OAN, which is a Trump favorite, more Trumpier than the Fox TV network, has a full on-time air reporter who covers U.S. politics, who's simultaneously on the payroll of the Kremlin. The reporter is being paid to produce pro-Putin propaganda for the Russian-funded network Sputnik. Maddow states, there's a lot of news today, but among the giblets of news gods dropped off on their plates for us today to eat the floor off is actual news that the super right-wing news outlet that President Trump has repeatedly endorsed, we literally learned today that the outlet the president promotes shares its staff with the Kremlin. I mean, what? She laughs, and if you've ever watched Rachel Maddow, you know exactly what that sounds and looks like. And soon after states, in this case, the most obliquely pro-Trump right-wing news network outlet in America is literally paid Russian propaganda. They're on-air U.S. politics reporters paid by the Russian government to produce propaganda for that government. Now, to my ear and to my eye, those seem like a lot of very specific factual claims. There's a lot of presumed facts in that statement. That they're paid by the Russian government for the purpose of producing propaganda for that government. Those seem like statements of facts. That is really literally paid Russian propaganda. That seems like a statement of fact. There's money being exchanged for that purpose. So that they share staff with the Kremlin seems like a statement of fact, not just opinion. So to my ear, to my eye, those seem like statements of fact, not statements of opinion. But let's read on. The California anti-strategic lawsuit against poll participation statute, Anti-SLAPP, is intended to provide a procedural remedy to dispose of lawsuits that are brought to chill the valid exercise of constitutional rights. The Anti-SLAPP law provides, in relevant part, a cause of action against a person arising from any act of that person in furtherance of the right of petition or free speech under the United States Constitution or California Constitution in connection with a public issue shall be subject to a special motion to strike unless the court determines the plaintiff has established a probability the cause will prevail on the claim. Okay, so this is not the best written anti-SLAPP statute I've ever written in my world, read in my life. I am a fan of anti-SLAPP statutes in general, especially when it comes to opinion. People should be allowed to express opinion. And if you're expressing opinion and a person doesn't like you, you should be able to go to court, get it stopped, and get damages. I have no problem with this. Now, there is a slight hiccup legally here that this is a California statute and we're in federal court. And the issue of when federal courts apply state level anti-SLAPP is a whole host of concepts unto itself we do not have time to get into. But some federal courts do apply that, and some states, some don't. So this court looks like it's going to apply this state issue. And we probably need a federal level anti-SLAPP to clarify this, which we don't have right now. But the courts are currently struggling with do they apply it or not. This court's going to apply it. I don't have a particular problem with them applying it. I do have a problem with the conclusions they come to under it, but that's another story that we're going to get into. The defendants have the burden to establish that the actions alleged in the complaint arise from protected activity. So Maddow has to show that this is protected activity. The law defines four categories of protected activity. Subsection E4 defines protected activity to include any conduct in furtherance of the exercise of the right in connection with a public issue or public interest. Plaintiff agrees with Maddow that they were exercising her constitutional rights and the statements do concern public issue. Thus, they do not contest the first element of the anti-SLAPP statute, so we turn to the second prong. In the second step, the plaintiff must show a reasonable probability of prevailing on the challenged claim. Plaintiff is suing for defamation. Under California law, defamation includes the intentional publication of a statement of fact, which is false, unprivileged, and has a tendency to injure or that which causes special damage. So this is pretty much the defamation claim everywhere. Some people phrase it differently, but it's basically the standard, right? So you're looking for a statement of fact. It has to be fact, not opinion. The fact has to be false. It has to be published to a third party. People have to be made aware of it. It can't be privileged. We discussed that before. And it has to have a tendency to injure or what special damages, which would sometimes be called defamation per se, is special damages, right? Assumed damage. So either has to cause damage or has special damage, which I'm assuming is the same thing as per se. So this is a defamation standard in California. Different courts phrase it slightly differently, but more or less this is the standard everywhere. We are familiar with this. We understand this. Great. In arguing that plaintiff cannot prevail on the merits of the claim, defendant makes two arguments in the alternative. First, that Maddow's statement is one of opinion, not fact, that's not defamatory, and that the statement is substantially true. The threshold question in a defamation claim is whether a reasonable fact finder could conclude the statement implies assertion of objective fact. If the answer is no, the claim is foreclosed. Yes, defamation only applies to fact, not opinion. It has to be a statement of fact. Again, to my ear, to my eye, these are statements of fact. It's literally paid Russian propaganda. They're literally on the payroll of it. They are being paid to produce propaganda for Russia. These seem like statements of fact. They are objective and measurable. These are things that could be proved true or not true. That's what makes them fact as opposed to opinion. Can it be proved true or not true? Yes, it could be proved true or not true. It could be proved to be true that they are or are not being paid. It could be proved to be true or not true they're being paid by the Kremlin. It could be true to be proved or not proved that the purpose of the payment is for propaganda. And that, all those things, that all seem like things that could be proved to be true or not true. They seem like statements of fact, not opinion, to my ear. To determine whether a statement implies fact, the court must examine the totality of the circumstances in which the statement is made. Fair enough, you do have to look to entire context. I agree with that completely. First, the court looks to the statement in a broad context, which includes the general tenor of the entire work, the subject of statements, the setting and format of the work. Fair enough, because this can swing both ways. You do want to look to the entire context. What looks like fact may not be, and what looks like opinion may not be. You have to look at the whole thing in trying to make the determination. That's fair. Second, the court considers the specific context and content of the statements, analyzing the extent of figurative or hyperbolic language and the reasonable expectations of the audience in the particular situation. Yes, hyperbolic language is not fact. And we see this also in advertising, right? Which we also call it puffery in the example of advertising. So if you say world's best coffee is your classic example, right? No one would believe that statement to be literally true. It's puffery. So if it is hyperbolic, if it is by its terms so absurd no one could believe it, it's not fact. So again, we look to context. But again, to my ear, this isn't here. These statements don't seem hyperbolic. They seem within the scope of something that could or could not be true, and they're not so absurd or being presented as so absurd by context that it's understood as hyperbole. It seems very clear from context, to my mind, that Rachel Maddow wants this to be understood as factual, not hyperbole, and a person would observe it as that. Whether a defamatory statement is one of opinion or fact is a question of law. Okay. Context can be determined that a statement of opinion is opinion and not fact. For the context of the statement, we could control whether the words were understood in the defamatory sense. Yes, that is definitely true. You want to understand how they're absurd. So it's not just the words, it's how they're delivered, the whole context of things. You want to look to the entire thing to understand how they were intended and also how they can be heard. The court first considers the medium in which the statements were made. Maddow makes the statement on the talk show program aired on MSNBC. The more statements lack formality and polish found in documents which a reader would expect to find facts, the more likely the statements are non-actionable opinion. Fair enough. Again, how the context is would matter. And so I guess the court is saying here that Rachel Maddow should not be understood to being provided facts. Her statement, her show is one of pure entertainment and pure opinion. It's not. No one could reasonably understand Rachel Maddow to be expressing things that are factual. So I suppose here that the court is calling Rachel Maddow fake news because it's not news. It's whatever else that would be. So the court here isn't using the term fake news, but the court's analysis is reaching that conclusion that because of the context, it shouldn't be understood to be news or a news program or presenting facts. Therefore, fake news. So the court isn't using that language, but that's the conclusion the court's coming to. Good job, court. Yeah. The court may consider whether the form is one in which a reader or a listener would be likely to recognize that the statements generally represent the highly subjective opinions rather than verifiable facts. Would a person understand this to be opinion rather than fact? Okay. The court now turns to the segment as a whole. Great, let's do that. The general tenor of the segment on the report is a report on the article, and Maddow's tone could be described as surprise and glee at the unexpectedness of the story. I don't know that I would describe it in those terms. The terms that I would use are more of a prurient nature. Maddow's reactions are one of excitement of a kind that could be described in prurient terms. Where she gets this, if you've ever seen Maddow, you kind of have an understanding of what I'm talking about. She expresses it with a glee and excitement that is more a simulacrum of adult behavior than anything else. She may be enjoying it in a prurient way. So she does seem to have a particular glee in her eye and giddiness that betrays a delight that she might be experiencing. Yes, I think I can manage to get that one by YouTube censors. Hopefully, we'll see. She begins by calling the story the single most likely sparkly story, and what would have been more ridiculous than most days in the news. She calls the news one of the giblets of news God's dropped off on the plates for us to eat on the floor today. Maddow responds that OAN shares his staff with the Kremlin, which seems like a statement of fact, and discusses the allegedly defamatory connection, then follows this by laughing. I mean, what? She concludes the statement by saying with a shake of the head, I mean, this is the kind of news we're supposed to take in stride that day, and we do our best. So she's using the word news, which does suggest, again, fact. Seems like fact. A holding in the Ninth Circuit in Parrington is applicable and worth quoting in full. When, as here, an author writing about a controversial occurrence fairly describes the general events involved and offers a personal perspective about some of the ambiguities and disputed facts, his statement should be generally protected by the First Amendment. Otherwise, there being no room for expression of opinion by commentators, experts in the field, figures closely involved in public controversy, or others whose figures might be of interest to the public. Instead, authors of every story would be forced to provide only dry, colorless description of facts, bereft of any analysis or insight. There would be little difference between an editorial page and the front page, between commentary and reporting, and robust debate among people with different viewpoints that is vital to our democracy would surely be harmed. This is true here. I am less convinced it is true here. I agree with the general statement. I'm just not so convinced it's true here. Maddow fairly describes the article that formed the basis of her segment, and she added her own commentary and opinions. I don't believe that they represent opinions. They represent statements of fact. And her describing another publication is also republication. So she's republishing the statements, which also provides her liability. So the underlying statements that she says, well, this is what I read, they are statements that are republishing. So that's a problem. Now, she does have a reporter's privilege element here. So there's that. But it's also not trivial. So I think the court is being a little bit bereft in its analysis here. It would actually have to get into the reporter's privilege and its applicability. But it's not even getting that far. It doesn't even see the republication issue, by which it would then have to analyze the reporter's privilege. Viewers expect her to do so, as it is indeed her show, and viewers watch the understanding with the understanding it will contain her personal subjective views about the news, which again, I have no objection to Rachel Maddow expressing her views and opinions. She's allowed to have any opinion she wants. I have no objection to this, and I think it is good that she expresses her opinion and makes it plain, because then people understand her bias, for better or worse. I think it's good that she expresses her opinion. So if she want to express an opinion about it, I think that's fine. But I don't view this as opinion. I view these as facts. And the reason I view it as fact is because it's demonstrable of being proven true. Are they paid or not? There are payment records. Are they employed or not? Employment records. Is it for the purpose of propaganda? Well, if it is, then presumably there's a contract or otherwise that it's being done for this purpose. So yes, these are things that could be proved true or false. So they seem like statements of fact. Thus, the court finds as a totality of the circumstances, the broad context weighs in favor of finding the statement is opinion and exaggeration, and reasonable viewers will not take the statement as factual. I cannot personally agree. And I also think it's more of a question for a jury anyway. These seem like, it seems like the kind of thing a jury could go either way on. So if a jury wants to say, no, it's hyperbole, I don't necessarily object to that as a jury question. The jury can make a decision whether or not it's hyperbolic, whether or not it would be understood, whether or not it's in fact it's a question of fact. So I think the jury should reach this. The fact the court is doing it is bothersome. It's not so obvious that it removes it from a jury question. It's not in that category. So it seems to me statements of fact, and a jury could reach a conclusion one way or another. To take it away from the jury, I don't quite see that here. The court now considers the context. Even where broad context is one of opinion, it's possible the particular statement may imply assertion of fact and thus constitute defamation. Hyperbolic statements are not actionable because the listener knows they should not accept the statements as fact. Fair enough, if they're hyperbolic, then no problem. A main issue here is whether the statements are hyperbolic. Because Maddow used the word literally, plaintiff asserts it would be unreasonable to find the statements to be hyperbolic. While it's noteworthy about literally, it's its conflicting definitions. The first definition of the word is in a literal sense of manner, such as the way an ordinary person or term uses to emphasize the truth of a statement. But an alternative definition is in effect, virtually, in an exaggerated way. Furthermore, under either definition, the term can lose meaning when considered in context. Although Maddow used the word literally, this does not necessarily mean it should be taken as factual. I suppose that's true, but again, that seems more like a jury question. Like, is the statement being used to, which sense is it being used in? Seems like a question for a jury. Is the word literally being used to describe it as true, or is it being used to describe something fanciful? Again, it seems like a question of fact a jury could reach. So the fact that it took it away from the jury here seems odd and not in keeping. It seems like a jury could look at it and make either decision, but I don't quite see it as a matter of law. The court, therefore, must consider the language surrounding the statement to put it in perspective. Or, a jury could do that. There are certainly facts presented in the statement that are not in dispute. So, again, that seems to, go the other way in some respects. because there are other things here that are understood to be factual. So there are other things in this report that are understood to be statements of fact. So since there are other things here that are understood to be statements of fact that a person would believe, this statement, which on its face seems to represent fact to my ear, that presumption is even elevated because it's in the context of other things that are presumed to be fact. These other things are presumed to be factual. So this thing seems factual on its face and would be understood to be factual because of the overall context. So it seems like the court is reaching the wrong conclusion. It is undisputed that the Daily Beast article is published, wherein the author opined the reporter had been reporting on politics for OAN and simultaneously writing for Sputnik, a Kremlin-owned news wire. There's no dispute that Maddow discussed the article in our segment and accurately presents the article's information. Indeed, the facts of her title, our segment, are not alleged to be defamatory. Staffer on Trump-favored network is on propaganda Kremlin payroll. Maddow provides these facts in a segment before making this defamatory statement. So the court here is saying that they provided the other facts, right? And therefore the statement at the end should be understood to be opinion because they presented the facts. But this statement is presented as though it are factual. There's no obvious delineation between the earlier statements that were provided and this statement that's provided. So there's no obvious way to say, oh, we've moved from fact into opinion. So this seems, again, to my ear, to be statements of facts, or at least it's a triable question as to it. I think a jury could probably go either way. A jury could understand it either way. And it's just an issue of what a reasonable person would perceive. And I think it could be perceived either way. So send it to a jury. It doesn't seem like a question that's a matter of law. The Ninth Circuit has held, when a speaker outlines a factual basis for the conclusion, the statement is protected by the First Amendment. Sure, if it's opinion, and you present all the facts, then sure, no problem. But was this presented as opinion? Quoting from the Ninth Circuit, a statement of opinion based on fully disclosed fact can be punished only if the statements and facts themselves are false and misleading. Yes, if you present facts and then present an opinion, your opinion is titled to protection. It's only if the facts are wrong. You can have any opinion you want, but the question is there a factual element wrong? And an opinion that follows facts does not become factual if it's presented as opinion. But was this presented as opinion? It doesn't seem so to my ear. Viewers were presented with details of the story before hearing the statement, and no additional facts were implied. Yeah, as to that, I can't quite agree. There does seem to be additional facts that are presented, and they're presented as fact. So I don't quite agree with the court here that this is a right conclusion as a matter of law. I think that there are issues here that raise jury questions. Further, in the sentence immediately following the contested sentence that OAN is literally paid Russian propaganda, Maddow said, almost as a clarification, that OAN's on-air U.S. politics report is paid by the Russian government to produce propaganda for that government, which doesn't seem like a clarification. It seems like an amplification, or maybe the same thing, or it definitely seems like a statement of fact. These seem like facts. That's an on-air U.S. political reporter. Seems like a factual claim. It's paid by the Russian government. Seems like a factual claim. To produce propaganda for that government. Seems like a factual claim. These don't seem like opinions. They're not presented as opinion. And in that time, Maddow made the defamatory statement. The screen was showing the article accompanying the text. One of the on-air reporters at the 24-hour news network is Russian national on the payroll of the propaganda outlet Sputnik, which again gets into issues of republication the court is just not analyzing here. Thus, Maddow immediately qualified the alleged defamatory statement with factual clarification, and viewers were seeing accurate information regarding the listing while listening to Maddow. Here, Maddow had inserted her own colorful commentary into and throughout the segment, laughing, expressing dismay, and calling the segment a sparkly story and one we must take in stride. She was very excited about the story, yes. In sum, when the total context surrounding the comment is considered, the court finds the context weighs towards a finding the statement constitutes opinion and rhetorical hyperbole protected by the First Amendment. So that is the end of the case, at least for now. of the United States District Court for the Southern District of California in the case of Herring Network versus Rachel Maddow. In this case, we learned that Rachel Maddow said some things about OAN News Network and a reporter on that network, and these statements, the court says, cannot be perceived as facts or hyperbole or just opinion and all the rest of it. And I have serious doubts regarding those conclusions. It doesn't seem to me. They seem like statements of fact that are presented as fact. And it seems like she is saying them as fact. It seems to me that there's some triable issues here. So I would imagine that this is going to go to appeal. Now, it is the Ninth Circuit Court of Appeals. So who knows what they're going to do or whether or not they will affirm or reverse. I mean, if we had to guess, we'd guess that they would affirm, right? So it may be that Herring Networks is out of luck. But I'm not sure I agree with the legal rationale here. It seems like they're statements of fact, at least that could be found by a jury. They're being presented as fact. And if the issue is that she was merely quoting Drudge, then that's a republication. Now, again, she might have a defense for that republication because of the reporter's privilege. But there's no analysis here by the court as to that aspect. They don't even see it. So if it is an issue, well, she was just reporting a fact, but she's republishing it. But she might have a privilege, but it's not being discussed at all. So I feel like there's legal deficiencies in this article all around, or this decision all around. So I think it should be reversed by the Court of Appeals. What the Ninth Circuit will do, probably not, if we had to guess. But at least for the moment, that's the end of the coverage of this case.